Right now, there's a toxic trend taking over the internet. Everyone with a ring light and a suit thinks they're an asset protection expert. They're feeding you strategies that aren't necessarily wrong, but often have subtleties that make them wrong, and the implementation of which is very critical. So be extremely careful. I'm Douglas Lodmell, and I spent the last 30 years protecting more than $6 billion in assets and working with the biggest families in America. Today, we're doing a reality check to separate the actual 1% wealth secrets from the garbage that will get you sued.
Do not buy a property in your personal name. Always set up some sort of entity, an LLC, an S-Corp, a C-Corp, a trust. Set up something, but never buy property in your personal name. If you do, you're putting yourself at huge risk and huge liability. Remember, always buy investment-related real estate in some sort of business entity.
Okay, so he's right. You should always buy investment real estate in some sort of entity. But he mentioned LLC, S-Corp, C-Corp. It makes a huge difference. It's not just LLC, S-Corp, C-Corp. First of all, LLC is the preferred choice. LLCs are incredible because they're limited liability companies. They have a different way in which a creditor has a remedy against them. It's called a charging order. Whereas if you use an S-Corp or a C-Corp, it's actually shares of stock, and a creditor has more access to shares of stock than they do have access to a membership interest in a partnership or an LLC. So it matters. The other thing he mentioned is S-Corp. I would never, ever, ever buy property in an S-Corp. An S-Corp has a very special taxation. And when you buy property in an S-Corp, and then you just take the property out just to put it in your own name, you haven't sold it, you haven't done anything, you have triggered a gain event and you will pay the taxes. So the biggest mistake you can do is actually put investment property in an S-Corp. You're better off with it in your own name than you are with it in an S-Corp. But the general rule is use an LLC for investment property. It should not be taxed as an S-Corp. Comes in the same tax problem. And then that LLC should also not be in your own name. It should be in your holding company. And that holding company should either be another LLC or it should be a limited partnership. And it's actually the limited partnership that I prefer. And then ideally, if you have enough in assets, you would top that all off with an asset protection trust like the Bridge Trust.
One of the craziest divorces I have seen in my life. European football star Achraf Hakimi cheated his wife out of his $70 million by putting it in his mother's name. He had zero net worth on paper. And the Spanish court ruled in his favor, finding that he had nothing to divide in this marriage. Then his wife, who was worth only $6 million, had to pay him half because her money was titled in her name. In America, that wouldn't have been allowed to happen. The money would have been put back into the marital pot.
Okay, well, she's right. In America, that wouldn't have happened. So putting your assets in someone else's name, particularly your mother, particularly if you were a footballer and you have $70 million and you are a very big star with a really clear source of wealth, a U.S. court would simply look at that and say, yeah, that's marital asset, putting it back in and divide it. So I can't comment on the Spaniards. Obviously, they saw it differently. This highlights the importance of getting advice in the country that you actually live and where the court case would be adjudicated. Advice from another jurisdiction is likely not going to help you. So be aware. Planning for a divorce is tricky. You can't just move assets around. A lot of people think, oh, I've been married, but all the assets are in my name. Therefore, I'm free to do whatever I want with them. That is not true in America. You are not free to do whatever you want. The court needs to determine whether those assets are part of the marital estate or not. It doesn't matter if it was in your name or the spouse's name. What matters is how the court deems the assets from a community, marital, or separate property status. So be aware, pick the right jurisdiction, and know what you're doing.
You guys, let me ask you something. I can't believe I keep on having to ask this, but when are you guys gonna stop relying on lawyers? When are you gonna stop relying on them to do the right thing? Defend you in your case, represent you appropriately, and do what's correct. What is it going to take for you to actually understand that lawyers, they're not for you. They're for the court and the state. Wake up.
He's expressing some frustration with lawyers, and to some degree, he's correct. There are a lot of cases in which your interests are not aligned with your attorney's. For example, in divorce cases, your attorney's interest is actually to drag this divorce out as long as possible with as much fighting as possible, and ideally go to trial. That's how, at least financially, they're going to get the greatest return on you as a case. In many other cases as well, your interests are not fully aligned. Sometimes you also have a lawyer that is working for you, but also working for another party. An example would be your insurance company hires a lawyer to defend you on an accident. They actually work for the insurance company. The insurance company is going to hire them again. You're not. You're a one-time case. So if there's a chance for them to actually get out of paying by seeing something, that is a risk. And I advise clients who do have those cases to hire their own attorney. He's not correct that all lawyers at all times are working for the courts or the system. That's not true. Your attorney is working for you. And many, many times your attorney is very much working for you and the only one working for you. So I wouldn't throw all lawyers in the same bucket, but I do think it's very, very important that you look at the alignment of interests. And financially is the primary interest that you need to make sure is aligned. And again, like the divorce case I mentioned, it's very much important that you understand where your lawyer's financial interest is as compared to yours.
It's very hard to be rich now because most people are so concerned with making money that they never sit and think, what would I actually do? Let me ask you a question. If I gave you $50 million today, take it. Where would you put it? Because you put it in the bank, they'll take it.
I don't know.
On an exchange, they'll take it. You can try and put it on a Trezor and hide the Trezor.
You're gonna get killed, right?
Well, you have to make sure no one knows about that Trezor. And you have to make sure they don't put you in a police cell and say, look, if you don't tell us the seed phrase, you're staying in this room for the rest of your life. You put it in gold, how are you gonna move gold around?
Yeah, what do you do?
What do you do with it? You buy property, but then you have to
take the property.
Well, they'll take the property. So what do you even do with money? Then you realize that power is loyalty and loyalty is power.
Power is loyalty and loyalty is power.
So the only way you can truly set yourself up to go to jail
is have loyalty.
Is to have other people who can fill your place when you're in jail.
I'm not sure what he's talking about. I mean, if I was given $50 million and I put it in the bank, it's going to be there. I have lots of clients with $50 million in the bank and they don't take it. So when he says they'll take it, I don't know what he's referring to. Is he referring to a lawsuit? Is he referring to the mafia? Is he referring to the government? I mean, it doesn't make any sense. So what he's saying doesn't make sense to me. There are plenty of places that your money is safe, brokerage accounts, bank accounts. If you have an asset protection consideration, that's different. You may need to have trusts and companies and so forth, but he's talking about a fundamental systematic problem where there's nowhere where you can place money that's safe. Simply not true. Every billionaire out there has plenty of money in the bank, even not billionaires, even just regular people with a few $5 million, $10 million have money in their brokerage account and it's still there. I think he's maybe trying to be reactionary and I'm not sure what his agenda is, but it doesn't make sense to me.
So can you move assets during a lawsuit? A creditor has no cognizable interest in the assets of a debtor prior to obtaining a judgment. Anyone can transfer their assets all day long until the sheriff shows up with a writ of execution pursuant to a court order. So if you've been sued, worried about a lawsuit, divorce, or similar concern, what will happen if you move your assets during a lawsuit? Moving assets during a lawsuit is often called fraudulent transfer, fraudulent conveyance, and now called a voidable transaction. And it's when somebody transfers or converts a non-exempt asset, such as cash, stock, or real estate, with the intent to delay or hinder collection by a creditor. If you move your assets into one of those during a lawsuit, because a judge can easily undo the transfer. Whereas an offshore trust is outside of the local court's jurisdiction, and your local courts do not have the right to issue court orders to our foreign trustee/law firm. Now, this isn't legal advice. Talk to an attorney for that. We have attorneys on staff who you can talk to, so visit our website and fill out a free consultation form for that.
Okay, so he's just simply pointing out that you are free to transfer the interest in your assets at any time until you're not. So he's correct. Even if you get sued, you still have the right legally to transfer your assets. However, you also have the risk that a transfer done with an intent to delay, hinder, or defraud a creditor could be deemed a fraudulent transfer, voidable transaction, as he said. Now, if he's implying that you can just transfer it to an offshore trust, and therefore that voidable transaction or fraudulent transfer will not apply, he's not quite right. The voidable transaction or fraudulent transfer still applies. So the court may not be able to reverse the transaction, which is the normal remedy for a fraudulent conveyance, is to reverse the transaction. But if the transaction is to an offshore trust, they may not be able to. But this is a very tricky area area of law, and you need to be very careful. Just because you can do something does not mean you should do something. So definitely you need to speak to an attorney about your situation. Don't just listen to TikTok advice around asset protection.
You won't believe this, but you don't need an LLC. LLCs do not save you taxes. LLCs protect you from legal liability. And as an individual, you can operate your business by using your social security number and your name, but you would report your income and expenses on Form Schedule C of your personal tax return without having an LLC, which means you can still take business deductions. As tax professionals, we prefer having an LLC because it would separate your business income and expenses from your personal income and expenses. And the reporting through the business LLC ensures a more favorable outcome for your tax liability.
Okay, so he's correct. You do not have to run your business through an LLC. You can report it on a Schedule C on your 1040. However, it is not advisable. We do not advise clients to do that. There's one main reason. A Schedule C does not have a balance sheet. It only has an income statement. So yes, you're going to get the proper income, expenses, and therefore adjusted gross income for your tax liability. But the IRS doesn't like it when they can't see the balance sheet with the assets. And so you're much more likely to be audited if you put significant income on a Schedule C. Whereas on an LLC or other corporate type tax return, you have a balance sheet and an income statement. Therefore, IRS is more comfortable when you file your taxes. Also, from a liability standpoint, it's simply better to run your business through an LLC or another company. Again, be careful with the taxation. There is the legal entity, which is an LLC, and then there's the taxation of that entity. And remember, an LLC is a legal entity, but the taxation could be S-Corp taxation, C-Corp taxation, partnership taxation, or even disregarded entity taxation. That has nothing to do with the business structure. So you want to make sure that you're getting tax advice and legal advice both on how you set up your businesses. Click the link in the description below to book a free asset protection analysis with my team. And let's build your financial fortress today. Remember, it's your money. Act like it.